Hello, my dear friends. I am Upma Awasthi, and on behalf of the team of Bullseye, I'd like to welcome all of you to this video session. Today, we are going to be taking an overview of the subject of law of contract. Now, students, right from buying things of everyday use from your neighborhood provision store to buying something big as a new house or your brand new car, everything in our lives is guided by the law of contract. Whether it's your relationship with your tenant or landlord, or whether you are an employer or employee, your relationship with each other will always depend on the contractual obligations and duties that you lay down for one another. Let us begin this session and understand what the law of contract as a legislation is actually doing. If you take a look at this slide, you will see this illustration where A tells B that I will sell my house for rupees 10 lakh. Now we are going to try to decipher a few things from this very statement. Well, if you look at this slide, it is telling us that by virtue of this statement that was given in the previous slide, A is specifying two things to B. And what are those two things? First is what A is willing to do. So what A is willing to do is he is willing to sell his house to B. And the second thing that it is specifying to us is what A expects B to do, and that is he expects him to pay rupees 10 lakh for the house in return. And this is exactly how the law of contract operates. Let us move further in this session and try to get a better insight. Now, I would say that an agreement and a contract overlap as far as certain features are concerned. Now, let's take a look at the slide. Contracts are based on an agreement. So something, students, that you can definitely be sure of are that a contract has all the elements of an agreement. And if you simply put it like the slide tells us, agreement has two elements, that is offer and acceptance. So what will turn an agreement into a contract? What is that one defining feature which tells us whether an agreement can be called a contract? And friends, that special feature is the feature of legal obligation. Legal obligation simply means whether you intend to create certain legal consequences for one another in case the contract remains unfulfilled. So I will give you an example of an agreement. When I decide to go for a movie with my friend, that is simply an agreement. It's a social agreement. But if I attach a legal obligation to it, that is, let us take a hypothetical situation that if you do not come for the movie, I am going to basically drag you to the court, or I will file a legal suit against you. So in this case, I have created an intention of creating certain legal consequences. So our differentiating feature will always remain legal obligation. Moving ahead. Now, legal obligation, this slide will again tell us how legal obligation basically sets an agreement apart from a contract. So, if we have an agreement and it has the element of legal obligation, then students, it will be a contract. However, if there is an agreement but there is an element of only social obligation attached to it, then it will not be a contract. So if we want to basically understand how agreement and contract they overlap is, see, agreement has the elements of offer plus acceptance. Clear? Now, this is simply agreement, but if we attach the concept of a legal obligation to it, then it will become a contract. So, agreement, as the slide is telling us, is offer plus acceptance. Now, what are the features of an agreement? So, it is an agreement between two or more persons. So, if we go back to our first slide where we spoke about how A made an offer to B that I am willing to sell my house for rupees 10 lakh. So, this till now is an agreement. If both of them decide that okay, I will sell my house and you will pay 10 lakh in return, in this case it's an agreement. Now, what is that specific purpose for which the agreement has been entered into? And that specific purpose is for the sale of house. And now, when the agreement specifies certain rights and duties between such persons, so the rights and duties, of course, are that the minute you pay the money, A will be duty bound to sell the house and B will acquire a right over that house. What are the elements of a contract? Now we are going to place the same illustration into a contract. Now let me tell you something, that the minute A and B decide that in case either of the terms on their part remain unfulfilled, then they can involve the court or a judicial body in order to enforce that contract. So here, elements of a contract say that first of all you need a minimum of two parties, and one of the parties must be making an offer and the other party should be accepting that offer. So A offers to sell his house for rupees 10 lakh and B accepts to sell that house for rupees 10 lakh. The intention to create legal obligation, of course, is very important. Once there's an offer and acceptance, and if there is not going to be an intention to create a legal relationship, then it will simply remain a social agreement which cannot be enforced by a court of law. Then the object with which you enter into a contract should always be lawful. That means you cannot enter into an agreement with each other to do something that is unlawful. Now, if A plans to sell his house to B and B accepts it, it's a completely lawful thing to do. But if, however, A says that you are going to sell this house to me and I will be later on using this house for the purpose of prostitution, here the object becomes unlawful and such a contract will never be valid. It will never be in a position to be enforced by the court of law. The next element that we are talking about is the capacity of parties. Now students, you have to remember that we are talking about a three aspect capacity. We are talking about mental capacity, then we are talking about age capacity, and finally we are talking about legal capacity. By mental capacity, I mean that the minute you are the party that is either making the offer or the acceptance, you should be mentally fit. You should not be a mentally unsound person before you enter into a contract. Otherwise, it will be presumed that due to mental unsoundness, you do not understand the nature of the contract, and that is why you lack the capacity to enter into the contract. The next capacity we are talking about is the capacity of age. So you have to be above the age of majority in order to enter into a contract. In case you are a minor, the contract entered into by you will be void and it will not be in a position to be enforced by the court. And finally, we are talking about legal capacity. So you should not be suffering from any kind of legal disqualification before you enter into a contract. Now friends, when you enter into a contract, the next very important element of a valid contract is free consent. Whether you are making an offer that is of selling your house or whether you are accepting the offer that is you want to buy it for rupees 10 lakh, what is really important is that both these decisions, whether the party that's making the offer, whether it's the party that is making the acceptance, both of them should do it with their free consent. It should be voluntary. They should not be under any kind of pressure or influence before they make the offer or acceptance. Let us move ahead and discuss the remaining essentials of a contract. Another important element that will decide whether a contract is valid or not is the certainty or clear terms. Now, if I say that I am going to take you out to lunch to the best restaurant in the city. Now, in this case, this is a very uncertain offer because the best restaurant to one person may not be the best restaurant to another person. So, it's a very subjective thing, first of all. Secondly, it's not clear, there's ambiguity in it. So, your terms and conditions in a contract must be absolutely clear. They should not give rise to any kind of doubt. They should be completely unambiguous. The next element is possibility of performance. Now, when you enter into a contract, obviously you are entering into a contract for a specific purpose, and whatever that purpose or final object is, it should be capable of being performed. So if a person says to you that I am going to bring the moon and the stars for you, of course it is very natural that it's not possible to perform that. Or if a person makes a claim to you that I am going to bring this dead person back to life if you give me 2 crore rupees, now the possibility of performance of such an act is absolutely nil. So if you enter into a contract which is impossible to perform, then it's going to be a void contract. Finally, a very important element is of consideration. Now, when A says to B that I will sell my house to you for rupees 10 lakh, in this case the house and the rupees 10 lakh are consideration, because consideration, if you look at the basic meaning of it is something of value for one another. If A is giving his house to B, then B in return is also giving rupees 10 lakh to A. So there is a value addition on both sides. If A is giving away his house, he is also getting rupees 10 lakh in return. And the same way, if B is giving away rupees 10 lakh, he is also getting a house in return. So this is how consideration works. If there is not an exchange of something that has value for both the parties, then it will either be gift or it will be charity if only one of the party benefits. And as we've already discussed, there has to be an intention to create certain legal consequences. So, what do we understand by the term legal obligation? Now, legal obligation, it is that duty which is enforceable by law. Now, agreement has to give rise to a legal obligation in order to become a contract, and that is why this last quote says all contracts are agreements, because they always have the element of offer and acceptance. But all agreements are not contracts, because every agreement may not attach the ingredient of legal obligation. Now, how can a contract be created? The slide tells us you can either do it orally or you can do it in writing, which, due to this change scenario where information and technology has taken over all the fields and spheres of our lives, contracts can be entered into even through electronic means. So the Information Technology Act has given full recognition to contracts entered through electronic means. It can be entered via implied method, that is where you have to infer by a person's conduct, or there can be a combination of all these above factors, that is you can do it orally or in writing or through implication. Now we are going to look at the types of contracts. There's a valid contract, there's a void contract, there's a voidable contract, illegal contract, and unenforceable contract. Let us discuss the first type of contract, that is a valid contract. A valid contract, as the slide tells us, it satisfies all the conditions that are prescribed by the law. An example is, if X offers to marry Y and Y accepts the offer, this is a valid contract. And this illustration completely fits into a Muslim marriage, which is a pure contract, and there has to be an offer and there has to be an acceptance. So this will be a valid contract, and in Muslim marriage, consideration amount is the mahar or the dower. Then the next type of contract is void contract. Now it is valid when it is entered into, but it subsequently becomes void because of either of these three. It can be due to impossibility of performance. Now, say for example, you booked a marriage hall and you paid the money, and of course, the other person also gave you the commitment that the marriage hall will be available to you on the said date. But before that said date, due to a mishappening, the hall burns down. So, in this case, it becomes impossible to fulfill the terms of the contract, and that is why such a contract will become void. There may be a change of law. Now, as per law, you might be allowed to indulge in the sale and buying of a certain good at a certain time. But subsequently or later on, if there's a change of law and you are disallowed to continue with the buying and selling of such goods, then again such contracts will become void. And if there's an absence of an essential valid of a contract. So in the previous 3 to 4 slides we discussed what are the various elements which are essential for a valid contract, and if either of those are missing, say for example, if you do not have the mental or the biological capacity, that is, you are a minor when you enter into a contract, then such a contract will again be void. So illustration here is X offers to marry Y and Y accepts the offer, and later on Y dies. So in this case, the possibility of performing this contract is impossible. The next type of contract is voidable contract. Now a voidable contract is a contract which continues to be valid until and unless it is avoided by one of the parties. Now one of the essential elements is missing. So say for example, when you entered into a contract, but at that time your free will or free consent was missing. So later on, if you can prove that in the court, so the minute you're going to prove that, till that point it's going to be a valid contract, but thereafter the contract is going to come to an end, and that is why it's said that a voidable contract is a valid contract till it is avoided by one of the parties. Illustration is X threatens to kill Y if Y does not sell his house for rupees 1 lakh, and Y sells his house to X and receives payment. Now in this case, the option that is available to Y is he can approach the court and later on prove in the court that his consent was not free, and he can return the payment of 1 lakh and can get the contract avoided. Illegal contract. Now an illegal contract is unlawful and it cannot be enforced by law, so it's void ab initio, that is from the very beginning. An illustration would be X enters into an agreement with Y to kill Z in exchange of rupees 5 lakh. So right from its very beginning, right from its very inception, it is void, it has no validity or acceptance in the eyes of law, and that is why we term this contract as an illegal contract. And similarly, unenforceable contracts are contracts which are absolutely valid, but they cannot be enforced by the court either due to the application of doctrine of lashes or doctrine of limitation, which basically means that if you're an aggrieved party, if you're an affected party under the law of contract, then by virtue of the Limitation Act or doctrine of lashes, you must approach the court within a reasonable time to get your contract enforced. If you're going to approach the court after an unreasonable time, then the court, due to the Limitation Act, will not be able to help you until and unless you have an absolutely reasonable cause for the delay about which the court is convinced. So I'm going to conclude this session by bringing one fact to the forefront, that contracts are ruling a lot of aspects of our lives, so they become very pertinent as far as everyday functioning of our routines is concerned. So the contract law provides a remedy. So if two parties, they promise to do something for each other and one of the parties fails to do so, which leads to certain type of monetary or any other type of damages, then there is a remedy available where you can approach the court for either the enforcement of a contract or for a due compensation. And it finally very clearly sets out what are going to be the rights and duties of each party. So friends, with this we've come to the end of this session. I hope you now have a fair idea about what the law of contract is all about. Thank you very much for your time, and please write into us and do let us know about what you feel as far as the content of the videos is, or for any other query. Thank you very much for your time.